Lordship. State your Lordship. And it's an emergency matter. Wherever the material facts have been suppressed, material facts have been suppressed, and he is a subsequent purchaser, and he obtained the order of from the land single bench. So it is for the end of the list, your Lordship. But this is the first occasion we are appearing. ಇವತ್ತೇ ಒಂದು ಅವಕಾಶ ಸಿಕ್ಕಿತ್ತು ತಮ್ಮಿಂದ.
ಅವಕಾಶ ಪ್ರಶ್ನೆ ಅಲ್ಲ, ಏನಾಗಿದೆ ನಿಮ್ಗೆ? ವಾಟ್ ಇಸ್ ದ ಪ್ರಾಬ್ಲಮ್ ವಿತ್
subsequent purchaser comes before the writ single bench and makes a writ petition seeking the conversion of the land.
what is the list about?
Malad, that the directions was given in the writ petition to the chief secretary to take actions against the deputy commissioner of Ramnagara and report to the court. But we have not reported to the court because that the chief secretary has been called out and the contempt is going to be initiated.
It comes before
Lordships kindly of serial number 24 in the first list. So that matter may kindly be taken up after 2 weeks.
no problem.
Pardon me, my lords.
24. 24.
Serial number.
Sir.
What is the number? 24.
Yes, please.
All right, 24 after 2 weeks.
Serial number 5, my lord.
Five.
Section has to comply. Only name has to return.
What do you want, madam? Time?
Monday can.
You want time? All right, 2 weeks. That's all?
Serial
number
18.
18? All right, 2 weeks. All right.
My lords, may I make a small submission? My lords, on 16th January, my lords had taken a revenue appeal. It came to be dismissed. However, the judgment came to be released yesterday. There's a typographical error, my lords. Instead of the appeal being dismissed, it has been written as appeal is allowed. My goods has been stuck, my lord. It's been seized.
There was an appeal by it was an appeal that your lordships had heard regarding that, my lord, confiscation without seizure. The year after, my lord, the matter was.
That is,
Kiran sir, ready today.
On the operative portion.
ಅದು ಯಾವ್ದು ಅದು ಇವಾಗಲೇ ತರ್ಸಿ, ಒಂದು ಲಿಸ್ಟ್ ಮಾಡಿಸ್ಬಿಟ್ಟು ತರ್ಸಿ.
And in para 6, my lord, it is there is another error. In para 6, my lord, it is recorded that I have no objection for release of the goods, which is not, my lord, consistent with.
All right, but please get that just immediately. Again, there will be. Sudha get it tharsi. Please be here.
Yes.
Whatever correction, both of you be here and get the proper correction.
What's up?
Serial number 80 and for the complaints
18.
18
18 has been adjourned. Somebody asked for time. Karmadi.
complainant date may come.
In every file, there will be a date, Mr. Mohan.
They have to file a complaint.
All right. Yes. 1 to 7, first time, 4 weeks for needful. Second time also 4 weeks. Fourth time also 2 weeks to do the needful.
I pray for the respondent number 6, my lord. My lord, the office note is that, my lord, I have not served copies of the report on the councils, for other councils, my lord. I have served it, my lord. I have filed the compliance affidavit also. But the office note
The
at
respondent,
respondent number 6.
what do you want now?
My lord, these office notes have to be, my lord, overruled regarding, my lord, non-service of,
Raised on report filed by R6. What is the objection?
objection is that I have not served copies on the other side,
Assert, is
which
it?
I have served.
Shri Arbati submits that office objection has been complied of by serving a copy of the report on the petitioner's advocate. None appears for the petitioner office to verify.
And serial number 2 also, my lord. I have received, my lord, it is for the petitioner to serve copies of the petition on me. I have received those, my lord. Serial number 2 of that note.
Same.
And serial number 3 affidavit also I have filed. That also has to be overruled.
All office notes, as prayed for office note 2 and 3 BT. Not
Great.
filing of acknowledgement. You have filed it, is it?
I have filed.
Shri Arbati submits that objection raised in office note 2 and 3 have been complied with. Office to verify and delete the office note.
Great.
Serial number 9, your lordship. Serial number 9. That is
It has been
regarding-
adjourned, madam. You can't mention like this. What do you want 9?
That is because dispensation, regarding the dispensation, I am with cancellation copies, my lord.
Anyway, it's adjournment. We are already adjourned. Dispensation now not possible. Yes.
This order is stayed with the Supreme Court,
What is stayed?
impugned order.
Then review does not arise for
The
consideration.
other family members are filed, not myself.
It has been stayed now, is it?
Stayed.
So you withdraw this RP.
No, because I don't know what is going to happen. And my other family members are filed.
Who has moved the SLP? Once the matter is in Supreme Court, what remains?
My lord, I filed this earlier and thereafter my other family members are filed. Because we don't have.
That you, yes. So now the respondents have filed, is it?
Yes, madam.
Who have gone to this Supreme Court now? What is your name?
Lokesh, one Mr. Lokesh Nadu has filed this SLP, madam.
What is your name? Leela Naidu.
My lord, my name is Leela Nadu.
All right. So Lokesh is one of the family members.
Yes.
Perfect. One of the family members. He is a respondent here,
Yes, madam.
Lokesh.
Yes, madam.
What is the serial number, Lokesh?
The serial number is
Lokesh Naidu. Respondent number 32 has filed.
Yes, ma'am.
ಯಾರು ಇಲ್ವಮ್ಮ? Respondent number 32 has filed SLP civil diary number 30264/2023. Full stop. So and so submits ಅಂತ ಮಾಡ್ತಾರೆ. So and so submits that respondent number 32 has filed SLP number so and prays for time 8 weeks. 8 weeks ಆದ್ಮೇಲೆ ಒಂದು ಡೇಟ್ ಕೊಡಿ. Yes. 6/3. Yes.
We had moved the matter, minutes.
Yeah.
There's one change, minutes. I just want to bring to your lordship's notice.
What is the change?
File ಮಾಡಿ. Copy. ಅವರು ಕಂಟೆಂಪ್ಟ್ ಅಲ್ಲಿ ಅವ್ರೇನ್ ಕಾಪಿ ಇಲ್ಲ.
ಏನ್ ಹೇಳಿ ನೀವು?
That's the only indulgence which we requested is now that the 42 sale deeds have already been executed, the possession minutes is delivered on paper. Sites are already in place. But the sites minutes, we are not permitted to go and occupy these properties. Now there is a lot of disturbance which is being caused. That's the reason why we moved the matter. And the remaining sites are concerned, sale deeds is to be executed. Now, as things stands, the subsequent development which I want to bring to your lordship's notice is
that after 21/3/2023 resolution, my lords, the communications were already sent to the government that this is the decision which we have already taken and therefore thereafterwards executing the sale deeds. If government has already come before this honorable court and said that we have no objection for implementation of the resolution dated 3/1/2023, now the government cannot go back, my lords. It will be virtually permitting them to go back from what was stated before this honorable court.
Government has not stated anything.
Yes, it has. Kindly have a look at
Stay order granted in my case.
292, my
Then,
lord.
my lord, your lordship will have to hear my writ petition.
Page 292. So far as that writ petition is concerned, my lords, I just wanted to say this. In the writ petition, my lord, somehow what they did was they have been successful in suppressing the two material orders which were required to be placed before this honorable court.
No.
The orders passed in RP where the undertaking is given.
All right, Ravi, what precisely you want now?
Lord, sir, I'm only saying, my lord, subject to further outcome of all these proceedings, your lordships may permit the sale deeds to be executed in our favor. It cannot be that 42 sale deeds are executed for remaining people, my lord.
Specifically directed, post it on 6. 6/3, my lord, your lordships have given a specific date on the last occasion.
Subject to the outcome, let the sale deeds be executed.
February 20th, what is the new thing developed to move the court?
Nothing,
My lords, the new thing which is developed, my lords, is only this.
nothing.
Yes,
I'll mention it close. The new thing is that 42 sale deeds are already executed in our favor. When we have gone there to occupy the properties, my lords, there is this police bandobast has been put in respect of this property at the instance of the writ petitioner, not by the government. When the sale deeds are in my name, my lords, why should they?
1 minute, 1 minute. To that extent, we'll, sir. Don't use police and all on this.
I don't think, my lord, that may arise. Only question is we have to take a decision as your lordships said. We'll take a decision at the earliest. my lord.
Take a decision and don't use, you see, we also understand that there will be several overtones.
My lord, no.
Wherever
Don't
civil,
think, my lord, these are all, my lord, trying to hype
There
up
is
something
by
which
chance,
doesn't exist.
by chance, sir. We are not,
Yes,
we are not accepting the statement
yes,
as
sir,
it is.
yes.
We are only requesting the learned Advocate General. You see, let there not be any overtones, sir.
That I agree, my lord.
Civil
Please.
matters, let it go on civil, the manner in which it should go. That is, there is nothing more.
Please,
Please instruct, you are the state. Please ensure that.
no police forces.
No police, nothing at all.
Lordships.
So, work on it.
My lord, that may not be required.
Bedwa? Sir, if Advocate General is assuring that.
Of course, my lords, I will not go beyond what he says.
I'll
Please
see that
don't
no
do that
police-
and whatever best that is possible.
Lordships.
We communicated once I get out. my lord.
Please communicate it. Inform whoever the concerned.
Please. my lord.
Let there be a very,
We'll do it right.
it must be, here it can be, parties can be fighting. There is
Right,
a
I
very,
Here
there
is there
should
has
be
been
no
congenial
agreement.
atmosphere before your lordships.
My lord, we'll immediately inform no
Absolutely.
police force. to go.
Yes, please do that. And whatever best is possible for all concerned,
We understand it's a human problem, my lord. We'll address it.
please have
And
it.
we'll pass the appropriate.
Thank you.
Look into it.
Please.
Grateful. my lords.
They wanted to implement the karma.
They wanted to?
Karma.
Don't record.
Has to be extended. ಅಷ್ಟೇ.
Whatever is there,
ತಿರ್ಗಾ move ಮಾಡೋದು.
sir, in this court always.
I know. Great.
None of this.
Complaints affidavit has to be filed by the. Okay, Lord, we have written to the institutions. Lord, institution has not forwarded the particulars. The issue is to,
So when will you file?
unless the.
ಬಂದ್ಮೇಲೆ.
ಬಂದ್ಮೇಲೆ.
Institution ಆದ್ರೆ ಸ್ಕೂಲ್ ಇದು.
Full.
ಏನ್ ಮಾಡೋದು? Wait for a while. Learned GA submits that the institution has not sent the details, correct?
Yes, ma'am.
Yes. 4 weeks.
Obliged.
Yes.
Petitioners in this matter. The lords have passed the judgment. First paragraph in the judgment, my lord.
ಎಂತ ಬೀಳುತ್ತೆ? writ petition,
In 20206
Ah,
of
page number.
2023, in the printed minutes, it is 50.
22-23.
print page.
We have to ascertain and make
50 minutes in that minutes.
What is wrong in this?
The order first paragraph minutes, the writ petitions have been filed by the student to the first year course in the academic year. 21-22 is there, my lords. It should be 22-23.
22-23, correct?
Lots.
Yes, ma'am.
All right, 22-23. Then. That's
And,
all?
Yes, my lords.
And the third and
That's-
fourth line in that same paragraph, we'll have to change
Same.
to 23-24 also. Consequently.
22 to 23.
Subsequent year.
20.
No, they then continued their studies for the academic year 23-24.
Yes.
So I am short of instructions because the copies of the applications
Morning-
appears to have been
morning.
filed served on them in the morning.
No,
Where the
yesterday I sent them,
persons-
my lords. I sent them yesterday.
Because in Delhi is
And
come
yes, sir.
today.
We are, I think there should not be any,
Ravi,
there is no
I'm-
issue.
if Keti is saying and if Ramesh is saying,
Short of instructions
not
that the
changing-
students are admitted for academic year 21-22 and they should be continued to further studies in academic year
But this,
23-24. I'm really not certain about it.
but
Lord,
Senate friend
Lord,
is saying
what
this
to-
because
I
there's
don't-
something happening in the Supreme Court on this mistake. That's the reason it has become necessary to.
I'm certainly not, there is nothing about this which is happening in the Supreme Court. I have seen the SLP draft papers. Certainly nothing is forthcoming from this.
not like that.
My lords,
Who
it
are
is-
you? You are the college.
I'm the college, but I'm
You are the college, no? Then
Yes.
you must say that. Which year?
to college, 8 and 9. They served it just now, my lords.
No,
In the
no, no.
morning, they have
No,
served
no,
it
my
is
lords.
what I'm
Yesterday I have
instructed.
sent it, my lords.
Sent it.
Then please, no, please call the principal.
I just,
and-
that's what I wanted to say, my lords. Your lordships may pass it over for
Ah,
30
yes,
minutes.
will, please
Make
call
one
your.
submission.
Huh?
May I make one submission? in this? There are two batches. There are two batches.
Sir, we will not get into that. Now somebody wants a correction. We are asking you. If all agree, we'll correct it. Otherwise, we'll leave it at that. That's all. Please understand, we can't get into this. Passover, please ask your AO.
I'll just ask them.
And whenever the matter, whenever you get instruction, you can mention.
Please,
Mr.
we'll-
Keti, Mr. Keti and Ramesh, kindly be here. We have permitted him to mention any time. Madam,
I'll be
ನೀವು ಇರಿ.
Lords, please.
None appears. None appears.
We grant 2 weeks time in this matter to file affidavit.
My lord, hardly 3 to 4 months is there.
Even
my
to
lord.
review
For
petition was there in
complaint-
Dharwad bench, it is not pronounced.
For
Kindly-
retirement, my lord. So only.
The back wages till the order we have given, reinstatement, we have filed a review petition before that, it is before the Dharwad bench today for pronouncement, kindly grant 2 weeks time.
My lord, a date may be given, my lord.
Around 2 weeks, call on such and such to file compliance.
Please, my lord.
Date may
File
be-
compliance affidavit, call on such and such date.
Grateful.
much.
My lord, there are two.
You have to do a lot of office compliances are there, please do it.
My lord, that item number 1 in this, what is the type copy of annexure T is the entire set of the 10 answer scripts taken under RTI and it's and the scheme of evaluation which the university has supplied. It's only for a reference purpose and it
Will not
was,
depend on that.
no, I won't depend. I have
what is-
taken the extract of that and
What
put
is the
it-
matter about?
This is the arbitrary evaluation of the answer scripts, not following the regulation, the
All
university.
that, no adjectives required. To the point. What, you,
I
you're
have-
challenging writ petition's order.
Yes,
What were you in the writ petition? Petitioner or?
Petitioner.
Petitioner.
petition.
It is dismissed now.
It is
What
dismissed.
is the prayer and writ petition?
The prayer is to evaluate the 10 answer scripts, which has not been reevaluated using the
To ask
regulation
for
of the.
reevaluation.
Yeah, my lord, once again, the reevaluation, because I had a grievance on that, that the scheme of valuation was not followed. And I have
For which course?
law course, Your Honor.
All right.
And I have given the data, sorry,
All right. Notice.
my lord, may I give it by hand because the university council is there.
Who is the university counsel?
Mr. Girish,
In addition, learned party in person is also permitted to serve the learned standing counsel.
my lord, waiver of condemnation for
So
delay.
that only after hearing. Thanks.
Commissioner, this matter, environmental compensation of 1.7 crores has been imposed on me. I am a builder, please, my lord. 10 years ago only, I constructed the apartment and I've handed over on the alleged violation that sewage treatment plant. There are certain violations in 2019-20 for 1 year. They've imposed 1.7 crores, please, my lord. In this, recently on February 5th, the amendment in the center, Parliament has passed the Amendment Act also, wherein the limitation is, they've limited the compensation to 15 lakhs. So I have been imposed 1.7 crores on this.
Is that correct?
That's
again,
again repeating. This is based on a formula, that's which for all the violations which have happened in the past. That's this amendment would not have any effect on.
How old is the building?
It's, I'm short of
OC
instructions
is-
on it. I'm just answering my lord's question. I don't have papers on this matter, That's like other
According
matters.
to him, it is 10 years old. All of a sudden, you can't impose crores of rupees
That's
compensation.
a 10-year-old building, assuming that that's what the council is saying is right. 10-year-old building, that's the STP, providing of an STP methods would have been a immediate sanction condition methods, which if it's not done, that would again be connected to a river body which is nearby. Methods. All these apartments which have been imposed.
Then take it, give him note, give him a copy, set up copy.
In
Come
fact,
back.
similar issue has been decided on the apartments only methods.
All
But in
right.
any event, methods,
Take
I have it
notice,
next
take
week. Yeah.
notice,
Yes, ma'am.
notice, Mr. Government is a party?
Yes.
Pollution board and DC's, they've issued a
All
letter
right.
to the
Mr.
DC.
Chaudhary accepts notice for one, GA for two, call on as service set of papers, call on such and such date.
Lordship,
Any urgency?
Lordship, I have just undergone insolvency and come out of it
That is why, if it's very urgent, we'll post it next week or week after next,
next week, please.
next week.
Office objections.
Office objection, compliance of office objection. Oh, you are not complied with office objections
Lordship,
also.
this is the log reports where only on off is written. The motor is just started and
So you will not depend on this.
will not be depending.
All right, learned advocate submits that he does. Appellant does not depend, does not place reliance on annexures AM1 to AN5. And
N it is some,
Hmm.
it's
AM1 to AN5.
AN.
And undertakes to furnish legible copies if need arises. Submission placed on record, office objection be, office note be deleted, notice, etc. Yes, next. Yes, what is this?
Delay, there is a.
Correct. What are you challenging?
My lord, lapse of acquisition proceedings, my lord.
Notice. Next. Government.
Government's appeal. Now the respondents were are teaching and non-teaching staff in respect of a private aided institution. But not their salary grants were admitted after they were appointed.
What is the order passed in the writ petition?
But not the order is that they are entitled for salary grant, but not from the date from which they were appointed.
But are you paying the salary now?
But not the- Yes, we are paying that.
Current salary you are paying.
A lot similar matters are pending before my note.
All right, notice.
Will be connected along with
Other
that.
Higmadi, learned GA submits that similar cases are pending consideration in such and such.
2476 of
Yes.
2015.
Notice and post along with that. Yes, next.
Wait, please, Lordship. I represent the complainant, my lord. My lord, the complainant and the accused are husband and wife.
Mhm.
There were several litigations were going on between them, which culminated in settlement, my lord, in MFA, my lord.
What is the contempt, sir?
Contempt, my lord, the wife, the accused her, agreed to execute Khulanama and get the same decree of divorce before the family court. Notice,
Notice.
yes, my lord, much obliged.
Vanaja. What is this matter about?
This is a matter when the first allotment was made by the housing board for a measurement of 18 by 20. Between the KHB and the.
Notice, notice.
Identical matters, my lord, already
Huh?
taken for consideration in writ appeal number 923 of 2023, my lord. I'm filing, my lord.
You know,
Identical matter, my lord, already
Correct.
issued notice, please.
there are advocates on both sides submit that issue involved in this appeal is similar to the one in WA 923 of 2020. ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ?
The notice, sir,
ಇದರಲ್ಲೂ ನೋಟಿಸ್ ಆಯ್ತಲ್ವಾ?
please.
All the matters have filed, Vakala.
Yeah, file.
Totally, there are
All
5 appeals,
respondents.
Please, no, my lords, respondent
except
number 6.
government.
One
Or
private,
how many respondents are there?
2, my lords.
All in
How many
two
respondents?
respondents,
Who is the second respondent?
government.
All right, GA directed take notice, post along with 923 of 23. Yes, next.
Please, my lord.
I appear to the government, not this was ordered to be posted on 11th of March.
These Milords,
2021.
there is some urgency, that is why we have moved it again, Milords. Milords, what was challenged before the learned single judge, Milords, was an act of according registration to a document in contravention to public policy. Milords, more specifically 131C of the Karnataka Land Revenue Act. Milords, what happens, Milords, here is, there is a tract of 120 acres of land.
So
Milords,
what
there are
is
no.
what is today's emergency?
Milords, on this basis, Milords, now the survey records are sought to be altered. There was no boundaries.
Who is altering the survey?
Milords, the respondent number 7, Milords, he has gone before the DDLR. And Milords, on the basis of this sale,
What is the order passed by in the writ petition?
Milords, the writ petition, Milords, the learned single judge says you have no locus, you might be a neighbor, but you don't have locus to challenge the.
He says that to whom?
To the current appellants. Even notice, Milords, what I mean to say, Milords, is notice was not even issued in this matter. At the threshold, Milords, on the first time.
So what do you want now?
That's all we are requesting, Milords, at this juncture, Milords, is on the basis of the sale deeds, Milords, let not the survey records be altered, Milords, pending disposal of the writ appeal.
Based
Because,
on the sale deed.
please, Milords, they are intending to alter the survey records.
They means who, sir?
Milords, the respondent number 7, Milords, purchases around 2 acres of land. I will just point out, I'll just say what has happened.
R7 has purchased land
Please,
from,
Milords.
from whom?
Milords, from a family of around 35-40 people, Milords. I'll just point out the sale.
How are you connected with the land?
Please, Milords, I shall just point out. If I could just take your lordships to running page.
ಸ್ವಲ್ಪ ಕತೆ ಹೇಳ್ಬೇಕಿಲ್ಲ ನೀವು ದಿವಸ ಬರ್ತೀರಾ ಪ್ಲೀಸ್.
ಗೊತ್ತಾಯ್ತು. 1 minute, Milords, 1 minute.
No,
May I take your lordships to 129 for a moment, Milords?
please tell us what the facts are.
Please, Milords. Milords, appellants are the owners of land bearing survey number 72, Milords. If your lordships could just turn over to 129, Milords.
Yes.
Your lordships will see there is a sketch.
Hmm.
It is a sketch which was prepared by the state government of Karnataka, Milords.
129, we are afraid there is no sketch. It is
Milords, Annexure G, Milords.
B.
Annexure G. Please. That
Very good. No, there is no sketch.
Page number yesterday sketch.
Milords, it is
It is not matching.
one.
You
I will
please-
just Milords, Annexure F for 1 moment. Milords. I'm so sorry.
Sir, the annexures are not matching, page numbers are not matching. Kindly do the needful, come back next week.
Milords,
Thank you.
I may just request, Milords, your lordship may just pass it over. Just give me 1 moment, Milords. If
Password
there
is
was
not
no
possible,
urgency,
Mr.
Milords, I
Ray,
understand.
please Understand, no password is not possible.
I
Next
could,
week.
if I could just, Milords, only 1 moment, I'll
Better,
just
better.
point out
Better,
one
better.
aspect. in the-
ದಯವಿಟ್ಟು next week ಮಾಡ್ಕೊಡಿ. Next week same day. Yes.
a date be fixed,
Yes,
because I am sure.
We'll fix next week on date.
No, there is an urgency. That is why we moved, but otherwise we would not have moved.
It is not possible today. At least you do whatever. Thank you. Yes.
Grateful, my lord.
Abhijit.
My lord, I'm appearing for the petitioners. This is a writ of public interest litigation. We are challenging the mutation order passed by the respondent number 3. Avoid annexure B1, my lord. And we are seeking to issue direction to respondent number 2.
What is the prayer?
We are seeking to issue direction to respondent number 2, 3, and 4 to consider the representation given by the petitioners and the villagers, my lord.
What is the prayer in the representation?
To reserve the land bearing survey number 44, which extend to 10 acres and 12 guntas as cattle grazing land, my lord.
Notice.
My lord, I appear for the appellant. These are minimum wage matters your lordship had heard earlier. Pleased to pass an reason why it has been listed today.
Then let it come
We
after
are still filing a few more appeals, my lord.
All.
All of them may be connected.
14th March, my lord.
14th March.
Interim order by kindly
By
Interim order.
consent, 14th March, interim order extended.
All are connected.
All are
30 point onwards, all are interconnected.
Yes.
State was given this matter on 5th of March.
Yes.
We moved a memo since there is an urgency in the matter, your lordship.
What is the urgency? Already.
Your lordship,
responded
we've,
to Madurai bench. What is this Madurai bench?
Post facto clearance.
Yes, what is the urgency, madam?
Your lordship, we have seek clearance from, we've got some information from the lordship. There was the Madras High Court matter was mentioned before the Supreme Court, and
What has the Supreme Court done now?
The state, the order of the stay of the Chennai High Court bench.
The state.
The state, but there is also a matter, similar matter before Bombay High Court. That is not stayed by the Supreme Court.
So one matter is state, the other matter is. Madam, you are Union of India. You can't take such stands.
That is one thing, but there is again a consideration about.
Did you know that this matter, Chennai Madurai bench was state?
No, I got to know yesterday. I sought for instructions. The other day I did not have full instruction.
your lordship.
One thing we want to tell, Government of India advocates for state government, central government. You are not adversarial litigation. You are only amicus. If there is a stay, there is a stay. No problem.
But instructions given to
You
me.
can't be fighting like private parties,
I understand.
where there is a list, you see, money recovery list or in declaration list. You are only, you must place the facts and leave it at that. You must, you see, when notice is, see, these are all matters which require some consideration.
We have
Your
no
lordship,
issue in
the-
granting approval, but because our.
Now
hands
that the
are-
Supreme Court has stayed, please give it.
Your lordship, the,
That is as regards 2021 OM, my lords. But she is seeking under 2018 notification.
Has it been, is there any stay order?
no, your
No stay
lordship.
order.
Then-
But the, my lord's notification was only for a limited period of 3 months, which has expired.
We made an application within the 3 months of.
What is the matter about?
Your lordship, we are seeking for post facto clearance, your lordship.
What is your occupation?
We are running an Ayurvedic Panchakrama center, your lordship. And as per annexure F,
See, under the Ayurveda Panchakarma. So what has happened? What is the problem?
your lordship, we have not seek the CRZ clearance, and there is interference
Please look
from
into
the
that. Pass
panchayat.
some
your
order,
lordship.
madam.
My lords, I require at least 15 minutes to canvass on this, my lords. Memo of documents are ready. If this honorable court will hear, I'm ready on the
Tell
arguments.
us. Now that, you see, if the matter is stayed by Madurai bench, we are not asking you to do anything. Do this. Union advocate cannot do anything. If what Madurai bench is saying, the matter is stayed by the Supreme Court, we'll simply say, please go to the central government, find out what is the position is there, Pass an order, examine it in accordance with law, pass an order.
Your Lordship,
But
and
that is
also the Bombay High Court
Stayed, my lords.
has
is
been
the
withdrawn,
old-
Your Lordship.
What is stayed, my lords, is the 2021 official memorandum, my lords, issued by Ministry of my lords, Environment and Forest. But she is not seeking clearance under that. She is seeking under 2018 notification, my lords. It is at
Please
of the
show
petition, my lords.
page
Kindly,
number.
My lords may see. It's a page number 43, my lords, of the petition. Only 4.3 clauses there, my lords, at page 43.
What is this notification?
Once this is the notification under which a window was made available.
1 minute, 1 minute. Notification dated 6th March 2018. Is that right?
Yes, ma'am.
Let us first understand what the facts are. You are running a Ayurveda institute.
Ayurvedic Center, Your Lordship.
What is the clearance that you want?
Since it is in the coastal area, we were asked to, the Panchayat had sent us a notice dated the Panchayat sent us a notice to get the clearance, Your Lordship. And thereafter on our
What is
first,
this annexure? What is that quashing you are asking, madam?
that is the impugned order that was passed by the
Proposal for post.
respondent
All
number
right,
one, Your
we
Lordship.
got it. Yes, now please tell us, what is this 43?
Well, it's 4.3 minutes, clause 4.3.
Yes.
This was the window made available for seeking CRZ post facto clearance.
Correct.
Now, my lords may kindly turn to the next page, 44.
Yes.
Subclause 3 minutes.
Yes.
I will read down. Such cases where the constructions have been commenced before the date of this notification without the requisite CRZ clearance shall be considered only by Ministry of Environment, Forest and Climate Change, provided that the request for such regularization is received in the said ministry by 30th June 2018.
Right.
The instructions I have is, there were hundreds of applications received, but only 3 were processed for the reason that it met all the aspects of the application. But, and all other.
Whether this
applications were
application,
refused.
this application was there?
I don't know the
Yes, Your
finer
Lordship.
details.
Our
if this applications were
application was made on 26/2018, Your Lordship, as per Annexure D. page number
26?
26/6/2018.
Annexure?
It was made at
Annexure
the
D,
far
Your
end.
Lordship.
Just 1 minute, madam.
Page 45, Your Lordship.
Right.
This was the application that we made, Your Lordship, as per the notification of 2018.
So what happened to this application?
And thereafter, this application came to be rejected. There was no
When?
spot inspection made
When?
on 35/2020, Your Lordship.
Page?
I'm sorry, Your Lordship. Page number 52, Annexure E.
Who rejected it? State government.
State government rejected this application, Your Lordship.
Who has to give this post facto?
Your Lordship, it has to first, the recommendation has to pass through the state government to the central, the Ministry of Environment, Your Lordship. And now on 15/10/2020, after the spot inspection was made, there was a recommendation that was made to the respondent number 1, Your Lordship. The state government has cleared our application, Your Lordship.
State government did not recommend.
15/10/2020, Annexure F, Your Lordship, 55 page number. Here,
What does the state government say? Requested to, the
it may be
proposal for
considered
Ayurveda
and granted.
Panchakarma, so and so, so and so, so and so, may be considered. It is not considered.
It has been subsequently considered, Your Lordship. As per page 57, the last line may be read.
Correct, yes, may be considered.
Considered and ratified, Your
So what happened?
So the state government has given us the clearance. Now this has to, the central government has to only approve this. It's just a mere formality, Your Lordship.
May I please point out, page number 56 minutes.
56,
It
yes.
is that same recommendation from the Karnataka government.
Yes.
ಅದರಲ್ಲಿ third para, Manoj,
Yes.
from the top. The subject was placed before, this is at, Karnataka Zonal Regulation Authority, meeting held on 16/11/18 and 17/11/18. The authority noted that as per para 83 CRZ 38J of CRZ notification 2011, construction of dispensary is a permissible activity, but not a hospital. Hence, the authority considered the activity as hospital, decided not to recommend the proposal to MOEF. So this is.
Your
not answered
lordship,
by the
ours
state.
is
Please
very
come to
clearly a
57.
dispensary.
Last two lines,
Hence it is requested.
57,
Yes.
third paragraph. Hence it is requested.
That the proposal of post facto approval for Ayurvedic Panchakarma Center constructed so and so for a total built up by Sridhar may be considered and.
So we requested and told you that you can't be an adversarial litigant. You must see, you don't read in between. Please read page 56, para 1, 2, 3, 4, 5. Regional director carried a spot inspection again. Thereafter come to a conclusion. Madam, laws are there, laws are always there to help the citizen, not to block their way. Come on, take down.
One more submission.
Reserve all this later in a better case.
Manoj,
Heard so and so, so and so.
Can I be allowed to place on record the memo of documents?
Your objections. Huh?
ಅದು ಮದುರೈ ಬೆಂಚ್ ಆರ್ಡರ್.
ಆಯ್ತಲ್ಲ, ಮದುವೆ ಬೆಂಚ್ ಸ್ಟೇ ಆಗಿದೆ ಅಲ್ಲ, ಮತ್ತಿನ್ನೇನ್ ಬೇಕು? ಕೊಡಿ, ಸ್ಟೇ ಆಗಿರೋದು ಕೊಡ್ತೀರಾ?
SLP ಅಲ್ಲಿ ಇದು ಆಗಿದೆ.
Stay ಆಗಿರೋದಾ? ಕೊಡಿ, that's good. Thank you. This is the right way of saying. Where is stay order? Where is the stay order, madam?
Page number, it's 11.
Page number 11. Condoned issue, meanwhile, there should be interim stay of the impugn. ಹೇಳಿಲ್ಲ. ಬರ್ಕೊಳ್ಳಿ. Petitioner is a this writ petition is filed with following prayers. Petitioner is a, you are a doctor, is it?
Yes, your lordship.
Is an Ayurvedic doctor running a center in the name of so and so, paste channel is there. He has filed an application as per annexure. Where is your original application?
That is annexure D, your lordship.
Annexure D dated 26/6/2018. For what? For post facto approval
Yes, your lordship.
for permissible activities pursuant to notification number SO1002, New Delhi, etc. Page 46 ali. The said application was initially rejected, is it?
Yes, your lordship, as per
Initially
annexure
rejected by
E.
the state government with a communication dated 1/2/2019. Holding that the activity is not a permissible activity as per the CRZ notification 2011. Subsequently, by communication into bracket annexure F dated 15/10/2020, the Principal Secretary to the Government, Ecology and Environmental Department conveyed to the Secretary, Ministry of Environment, Forest and Climate Change that not communicated, requested after holding a spot inspection, not after holding, requested that the proposal for post facto approval could be considered and ratified. In the said letter, it is recorded that the regional director ENV had carried out spot inspection on 30/5/2020 and submitted a report on the existing structures and the existing structures, full stop. After receipt of this recommendation by the state government, the government of India has rejected petitioner's request. First, plural. Petitioner's request has been rejected as per Annexure A dated 21/3/2022. Is that right?
Yes, Your Lordship.
On the premise that the official memorandum number 19-27/2015 dated 19/2/2021 issued by Ministry of Environment and Forest, Forest and Climate Change had been stayed by the High Court of Bombay and High Court of Madras. And the ministry had been restrained from granting permission on the basis of the said official memorandum. Assailing this, the said communication, the petitioners are before this court. Miss so-and-so for, what's your good name?
Rupali K. Trivedi.
So-and-so for the petitioners submitted that petitioner, which is that notification? With a
2000.
notification dated March 6, 2018. Into bracket annexure C. The ministry has proposed post facto clearance for permissible activities. Adverting to clause 4.3 thereof, she submitted that as per the notification, petitioner's activity was permissible and an application was required to be filed on or before 30/6/2018. Petitioner has submitted his application on 26/6 in time, has submitted his application in time on 26/6/2018. Delay, if any, has occurred at the instance of state government. Further, the order passed by the Madras High Court has been stayed in SLP Civil Diary number 33840 of 2023. Full stop. Learned, full stop. Para. She prayed that in these facts, she further submitted that after a spot inspection, the state government have now recommended for post facto approval as per annexure F para. Learned CGC, Miss so-and-so submitted that has filed a memo of documents furnishing a copy of the OM dated 19/2/2021 and a copy of the order dated 4/9/2023 in SLP number 33840 of 2023. Number 33838 of 2023, full stop. Para. We have carefully perused so-and-so, so-and-so. The petitioner's grievance is that petitioner's case is that petitioner is entitled for post facto clearance as per in terms of notification dated 6 March 2018. The last date for submission of application was 30/6/2018. Annexure D, as per Annexure D is the application and it is dated 26/6/2018, which is within the stipulated time. The state government have initially rejected have not recommended the proposal on by their communication dated 1/2/2019 and subsequently, after holding a spot inspection, state government have recommended for post-facto approval as per Annexure F dated 15/10/2020. Thus, the petitioner was, in normal circumstances, petitioner was entitled for consideration of its case as per, in the light of, as per notification dated 6 March 2018, Annexure C, full stop. However, the proposal has been rejected on the premise that the official memorandum dated 19/2/2021 has been stayed by Bombay and Madras High Courts. Full stop, para. In SLP Civil Diary number 33480/2023, video order dated 4/9/2023, the order passed, the order passed by the Madras High Court has been stayed. In SLP 33838/2023, video order dated 6/9/2023, the order passed by the Bombay High Court has also been stayed. In that view of the matter, the endorsement, the communication as per Annexure A is wholly misconceived and unsustainable. In the circumstances, this petition must succeed, and hence the following order: petition allowed, order dated certain such Annexure A is quashed. The respondents are directed to consider and pass appropriate orders in accordance with law on Annexure D in an outer limit of 3 months from the date of receipt of a copy of this order. Petition disposed of. Thank you. Next.
December. Identical matters. Annexure L1.
Correct?
Yes, ma'am.
Advocates on both sides submit that the issue involved in this writ petition is covered by the decision in
Only interim order has been
Interim
granted.
order.
interim order.
Interim order.
All right. In identical, submit that in identical case, interim order has been passed as per Annexure L, full stop.
L and L1.
L and L1, full stop. Notice, learned GA accepts notice for all right. Accepts notice for respondents. There shall be interim order in like terms of Annexure L and L1.
Only as per Annexure L1.
L1.
Only as per Annexure, correct?
Correct.
All right. There are only L1 mark.
Please.
Both agree as Annexure L1, interim order in like terms.
Please.
In this matter, is pertain to rejuvenation. 28 July 2022, there is an order passed by this court. If the directions which has been issued by this court is not complied,
Now it is WP.
this
WP, what is
matter
the
pertain to the rejuvenation of Vrishabhavati River Valley, which earlier was flowing in Bangalore, about 92 watts.
So what do you want today?
This court passed an order, this court passed an order, 28/7 for a moment, Your Lordship.
So what do you want now?
The government has submitted the survey report, Your Lordship. Based on the NERI, the status report has been given by NERI. Now the BWSSB and Policeman Court are all complied with the direction of this honorable court. Only
Sir,
BBMP
Fair enough. What do you want today?
has to comply in full as observed by this court on 28 July. So even last occasion also 5th December,
Status
same order was
report.
passed.
Status report.
Small
Yes.
accommodation may be given.
Last time also they took same time, Your Lordship, because Bangalore, already now we are having a water problem, scarcity and other things.
Lord, it is an action taken report by the BBMP.
They are all complied with the direction.
They must file action taken report. When will you file, Mr.?
Two weeks.
Learned advocate for BBMP seeks 2 weeks time to file action taken report. Full stop granted. Call on such and such.
My lord, that the name of Mr. Murugesh, my lord, has to be deleted as a counsel for BBMP. He is not appearing by mistake. My
Who
lord.
is appearing now?
My lord, is such Prashant.
All right. As prayed for by Mr. So-and-so name Hesreli. Name of Murugesh Charati be deleted and name of Mr. So-and-so be
It
deleted.
has to be deleted for only R2. For R3, Mr. Charati is appearing.
They all filed the status report. We don't-
do one thing, all of you file
Only BBMP is the
appropriate
problem always.
memos, let office take note. All right, thank you. Nothing, no order. Yes, next,
A short,
34,
short date may be given.
2 weeks.
That's what-
Yes, please.
34 appear for the appellant, my lords. This matter
Right.
has to be heard, my lords. So I request,
Yes, yes, of course.
please.
Yes, yes, matter be placed before roster bench 2 weeks.
May I request for the name of Vikram, you are to be deleted, my lord. Ms. Sumana Nagaran appears in both for the appellants. in
You
both.
file an appropriate memo and get it done. Thank you. Next.
Great.
I'm for the appellant, my lord. I seek accommodation, my lord, 2 week accommodation. Because
right.
my lords
All
observed
right.
that writ appeal 4,
No
5,
problem. So and so seeks time granted.
interim order may extend.
All right, interim order extend. Yes.
That Bajaj Trust. ಒಂಟಿತನ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಇದು. In fact, on the last occasion, my lord, I mean, when my lord, the court was about to pass an order for framing of charge, 270.
Of the complaint council.
Short Collins, Mr. Rojipura submits that additional advocate general is not in town. Seeks time, ಯಾವ್ದು ಬೇಕು date by consent Collins just date. Yes, next.
This case, my lord, I filed impleading application, site purchased by me. My vendors has farmed sites.
Come, at that, when it comes next.
ಹೌದಾ? My lord, before the roster bench ಅಂತ ಆಗ್ಬೇಕು ಅಂತ ಕಾಣುತ್ತೆ, because roster ಎಲ್ಲ ಚೇಂಜ್ ಆಗಿದ್ದಲ್ಲ.
ಹೌದು.
ಇಲ್ಲ ತಿರ್ಗಾ ಇಲ್ಲಿ ಬಂದು ತಿರ್ಗಾ ಅಲ್ಲಿ ಹೋಗಿ.
ಏನು roster ಏನ್ ಚೇಂಜ್ ಆಗಿಲ್ಲ. ಇದು CCC ಅಲ್ವಾ? ಇಲ್ಲೇ ಬರುತ್ತೆ.
ಇಲ್ಲೇ ಬರುತ್ತಲ್ಲ?
21.
ಇಲ್ಲ, ಇದು 21 ಅಲ್ಲ.
ಹೌದಾ? All right.
My lord, I'll be happy to go anywhere, my lord. Grateful.
Place it before this.
Because I would have opposed, but then, out of station ಅಂತ ಇದ್ರೆ last day.
ಆಯ್ತು.
Don't want to, my lord, say anything. Very
Appear
convenient,
for-
my lord, he gives out. Stay ಹೇಳ್ಬಿಟ್ಟು.
Petitioner's counsel, my lord.
Yes.
A date may given, my lord, because the respondent, Rajiv Gandhi University, be directed to declare my result, my lord.
All right. Shri Leonard Senior Advocate seeks time Collins such date. Yes.
The result has been announced, our result.
ಆಯ್ತಲ್ಲ, ತಾವು ಟೈಮ್ ಕೇಳಿದ್ರೆ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀವಿ ಅಷ್ಟೇ. Next.
Ash may kindly fix a date.
Final hearing, yes, it has to be fixed. None appears for petitioner. ಅಷ್ಟೇ ಏಪ್ರಿಲ್ ಅಲ್ಲಿ ಒಂದು ಡೇಟ್. Yes. Yes, ಆಯ್ತು ಅಷ್ಟೇ. ನೆಕ್ಸ್ಟ್ ಕರೀರಿ. ಇದೆ ಆರ್ಡರ್ಸ್ ಮುಗಿಸ್ಕೊಳ್ಳೋಣ ಸರ್.
Yes, but the allegation, they have, they disobey the order. Lord, your lordship may kindly, because I have produced these documents also.
We must state few facts, then
Yes.
something.
My lord, the subject, my lord, subject matter of the property was the father purchased it. There are 4 owners.
File ಕೊಡಿ ಮಾ.
Respondent continue the proceedings at the instance of third party who filed an application.
What is that we have done now?
My lord, your lordship,
Let us just see. 1 minute. Just 1 minute, hold.
Yes.
Vijay Kumar Swensus.
But I have not
Yes.
seen the, your lordship.
Just wait
Please.
for 1 minute. Vijay Kumar filed one OS, Prabhakar Naik seeking a mandatory injunction to put him in possession. Prabhakar Naik filed a suit. Kumar so-and-so seeking injunction. 330 has been decreed. Execute the decree in 330, which has been confirmed in RA number so-and-so. Vijay Kumar filed execution case. In the proceeding, complainant IA1 filed and the same has been dismissed in 2016. On appeal, same has been confirmed in RA number so-and-so. Further appeal, RSA directed parties to maintain status quo. In the execution proceeding, would be Ramadevi Shanoy and purchase the property. Do that in order status quo. Who are you complainant? You are claiming under whom? You are Hemlata Naik.
The claiming my right, what has happened? The property of.
No, first relation must be very
Yes.
clear. How is Hemlata Naik connected with this property?
Your lordship may kindly have it annexure yet at page 9.
Now, I'll help first.
I ಹೇಳ್ತೇನೆ. The Hemalata, that property was belonged to Hemalata's father. There are three sisters and one son. The one son has sold the property to them. We are not a party to that. Then, I have filed a partition suit, OS original suit in 339 of 2005 in the court of civil, that is annexure yet at page 9. In that, he was a party. He was impleaded as a party in the respondent in that case. But when that suit was pending, when I am claiming an independent right, he filed the colluded suit along with my brother Prabhakar Naik, and they colluded suit each other. But in fact,
that is why.
Yes.
Your problem is that your grievance is that, you see, though there is a status quo order passed in RSA 206 of 2018,
Yes.
in execution proceedings 132, her possession may be disturbed. This is your grievance. Is that right?
They not only disturbed in 2009, they are continuing to hold an inquiry contrary to the two orders passed by this honorable court. Status quo order has been violated. The status quo order is they obtained a collegiate decree that has been stayed by this honorable court in two proceedings. In
any event, what is that causing harm to you?
Whether once there was a stay order in execution petition, the judgment and decree and execution petition, whether that can be continued or not, the matter has been settled by the several judgment of the Supreme Court. I'll take your lordship,
No.
I'll
kindly listen.
Yes.
Now that, you see, the RSA, in the RSA, this court has said status quo.
Status
Okay, let us see that order. Where is that order?
Yes. But before that, may I request your lordship?
No, we must first, no. we
Yes,
will not-
I'll,
Please
yes.
show that order.
Yes. Your lordship will get it at the page 9 starts at 10.
Page 10.
Yes. There is arising out of the partition suit.
Parties are hereby directed to maintain status. What does it mean?
So far as there is a judgment and decree in they have obtained by them in OS number 330 of.
No, Prakash Shetty. Now, tamgon simple question kelta. Parties to maintain status quo andre yen.
ಚೇಂಜ್ ಮಾಡಲೇಬಾರ್ದಂತ.
ಏನ್ ಚೇಂಜ್ ಮಾಡ್ಬೇಕು?
ಇದು ಯಾವ ಪೊಸಿಷನ್ ಅಲ್ಲಿ ಇದೋ ಅದರಲ್ಲೇ ಕಂಟಿನ್ಯೂ ಆಗ್ಬೇಕಂತ.
ಅಲ್ವಾ?
ಹೌದು.
Perfectly correct.
ಹೌದು.
So now, please see what the order we have passed now under.
Before the certain things your lordship has not noticed. I'll place it. I have produced that copy of the order. I have it is there, the continuous stand, and they are continuing the execution proceeding contrary to the two orders of this honorable court. That is therefore, your lordship, kindly 1 minute, therefore,
Mr. Shetty, we will tell you.
Yes. Before that, your lordship, on 29 2023. Kindly see the order sheet, my lord.
29?
20th, in the month of 9, September 2023. Your Lordship has called for records. In spite of the order of this Honorable Court, record has not been called for by the Execution Court. 20 my lord, on September 2023.
Right.
Yes.
29 ನಾವೇನು ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಅಂತ ಮಾಡಿದೀವಿ ಅಷ್ಟೇ.
ಕಾಲ್ ಫಾರ್ ಮಾಡಿದ್ ಬಂದಿಲ್ಲ ಅದನ್ನ ತರಿಸಲೇ ಇಲ್ಲ, ಇವತ್ತಿನವರೆಗೂ ತರಿಸಲಿಲ್ಲ ಫೈಲು.
ಅಲ್ಲ ಆಯ್ತು, ಬಟ್ ಇವಾಗ ಇವತ್ತಿರೋದೇನು ಒಂದು ಸ್ಟೇಟಸ್ ಕೋ ರಿಗಾರ್ಡಿಂಗ್
ಇಲ್ಲ, ಸ್ಟೇಟಸ್ ಕೋ ಆರ್ಡರ್ ನ ಒಂದಲ್ಲ ಕಂಟಿನ್ಯೂಸ್ಲಿ ದೇ ಆರ್ ಡಿಸೋಬಿಂಗ್ ದಿ ಆರ್ಡರ್. ಈವನ್ ನೌ ದೇ ಪ್ರೊಸೀಡ್
ಮಾಡಿದ್ದಾರೆ ಅಂತ ಕೇಳ್ತಾ ಇದೀವಿ.
ನಮ್ದು ಒಂದು ಎತ್ತಿ ಹಾಕ್ಲಿಕ್ಕೆ ಹಾಕಿದ್ರು. ದೆನ್ ಅದಾದ್ಮೇಲೆ
today, yes, please kindly listen to
yes. But your Lordship may kindly look into that. I think I have, but if you are Lordship.
ಪೂರ್ತಿ ಕೇಳ್ಬಿಡಿ, ಒಂಚೂರು ಹೇಳ್ತೀವಿ. ಅದಾದ್ಮೇಲೆ you can make your point because order has already been dictated.
Yes.
Your grievance is that status quo order is being violated.
Violated.
According to Mr. Pai, para 6, we have recorded his statement. He says, we have said like this, complainant's grievance is that though there is an order of status quo in RSA 206, by virtue of proceedings in execution case 132, her possession may be disturbed. This is your grievance. Sudhakar Pai, learned advocate for A2, submits that until RSA 871 of 16 and RSA 206 are decided, complainant's possession shall not be disturbed.
Malad, the complaint not position. Malad, the order of this Honorable Court is the status quo order in OS number 330 of 2007 and execution number 132 of 2016 was status quo order was passed. Now what has happened? Malad, after interim order, they have make somebody to file application in the execution petition, and against whom there was no judgment and decree at all. He against him is prosecuting it, and in that they obtained an order for evicting me.
That's the beauty of the lawyers. Brain,
no, that is not. Whether when the judgment and decree.
Third party files an application.
In an execution.
He has no control.
Whether that is a permissible law, it is settled by the several judgment of the Supreme Court.
You get it clarified in that RSA.
No, not RSA, there is a status quo is there. It is my respect to submission is kindly be seen, my lord. I am not. This is all settled by the Supreme Court said once there is an executive court cannot go beyond the judgment and decree. Judgment and decree has been said.
That no, Mr.
No, you will not kindly see that. That is I have placed
enough hearing. We are not.
No, you are
not persuaded.
Quantitative order, they are proceeding it. That is my grievance.
No, our jurisdiction is very limited.
I am not asking you to stay of your Lordship order. The order of the dishonorable court has been violated, and
that is what is your case. According to us, it is not violated.
Your Lordship has not heard me. That was my grievance. I have not been heard when your Lordship kindly.
No, it is the manner in which we want to hear. That's a different matter.
No,
Please don't get it. Don't make such
Audio is muted, my lord. I'm sorry.
Appearing for the appellant, my lord. The order has
We
been
have
passed
lot of,
after hearing the caveator, my lord.
lot of office notes are there. You must be.
I'll
comply
comply
with
with the.
All right.
I'll serve the.
Compliance in 2 weeks, that's all.
The application filed for paper publication may be allowed, but.
Who has filed the paper publication? You have filed?
Appellant,
All right. IA1 allowed. IA1 of 23 allowed, fixing the date of hearing as,
kindly extend the interior model.
1 minute, madam. Fixing the date of hearing as 22nd April, publication on or before 22nd March, all right? Which paper?
Vijayavani paper.
No, IA1 disposed of. Next,
Obliged.
Shilpa Rani.
Mandamus, my lord, the survey number 79 in Shettigalli village, my lord, there are a lot of land, my lord, is a government Gomal land, my lord. The providing.
Prayer.
Prayer is Mandamus, my lord, consider my representation, my lord.
What is the prayer in the representation?
Representation, my lord, I'm the retired employee, my lord, government employee, and I've come to know the fraud alleged in the National Highway Authority has been paid the compensation to the respondent number 7 to 11, my lord.
Sorry?
Respondent number.
What is the prayer in your representation? Where is your representation? Page para?
My lord, my representation, sir, my lord, annexure N and P, my lord, page number 270.
270.
Please, ma'am.
That's right. You are Shiva Shankar.
Please, ma'am.
What is it you are asking for?
Conduct an inquiry, my lord, against the
Requested
compensation paid
accusers
to
to
the
get back
respondent
the
number 7
government
to 11.
land which is encroached and get back government money. What is this government land, government money?
Government land, my lord, in survey number 79, total 80 acres, more than 80 acres, my lord, more than 55 lakhs compensation is paid to the.
Just 1 minute, 1 minute. Notice.
Notice for R1.
Who are the other respondents?
State and private respondents.
Union of India, you are there.
11.
1 and 2, you are there, is it?
Only
1.
one.
All right. 2 and 3, GA, National Highway Authority, Shilpa Shah, no? Shilpa Shah, Miss Shilpa Shah advocate is directed to take notice for 4, KIDB Chandrasekhar, 5 and 6 Chandrasekhar, notice to 7 to 11. Next. Oh, then. Announcement. Yes, Mr. No, not pronouncement. We'll complete this, Pies matter. Prakash Shetty, ಸ್ವಲ್ಪ ಕಂಫರ್ಟ್ ಆಯ್ತಾ ತಮ್ಗೆ?
ಇಲ್ಲ ಕಂಫರ್ಟ್.
ಆಯ್ತಾ, ಹೇಳಿ.
ಒಂದ್ ಸ್ವಲ್ಪ ನಾನು ಹೇಳಿದ ಫ್ಯಾಕ್ಟ್.
ಹೇಳ್ಬಿಡಿ, ನೀವ್ ಏನೇನ್ ಹೇಳ್ತೀರಾ ಎಲ್ಲ ಹೇಳ್ತೀರಾ.
ನಾನು ಹೆಚ್ಚು ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡೋದು ಇದ್ರ ರಿಲೆವೆಂಟ್ ಮಾತ್ರ ಹೇಳ್ತೇನೆ. The order of your lordship.
ಇಲ್ಲ, ನೀವು ಒಂದು ಪಾಯಿಂಟ್ಸ್ ಫಾರ್ಮುಲೇಟ್ ಮಾಡಿ ಅದನ್ನ ಹೇಳಿ, so that it there will be focus on.
ಯಾಕಂದ್ರೆ ಇದ್ರಲ್ಲಿ ಸ್ವಲ್ಪ ಸ್ಟೋರಿ ಇದೆ, ಅದು ತಾವು ಅಂದ್ರೆ ಸ್ಟೋರಿ ಅಲ್ಲ, ಇಟ್ ಇಸ್ ಎ ರಿಲೆವೆಂಟ್ ಪಾಯಿಂಟ್ ಫಾರ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಕನ್ಸಿಡರೇಷನ್. The order of this honorable court in RSA number is your lordship, that status quo order may be kindly be seen, my lord.
Yes, page number, para number.
Page number 10.
Yes.
Then the question has been formulated. Then, my lord, the 3 questions has been formulated per 10-1.
Page number 10, my lord, pertains to RSA 871. Learned friend has restricted this contempt to RSA 206 of 2018.
RSA
206 of 2018.
ಅದು ಬರ್ತದೆ.
His submission.
He
has restricted this
contempt
to RSA 206.
Your lordships has to look into, because
This is what he wants to do in being spoken.
That I will come to later. That is the first order.
Disciple while issuing notice.
Correct.
Notice to accused number 1 dispensed with.
No, in the prayer itself, it is only 206.
Yes. How can you argue, my lord, 871?
Whether I can argue, your lordships also look into that. That is the judgment, I can place it. The Supreme Court said, my lord, if somebody played a fraud and obtained a fraudulent by author obtained a decree, this honorable court has to consider that I can place the judgment of. Your lordship, may first, then my lord, the annexure. My lord, that is also again that I have, the annexure B, my lord, kindly be seen, my lord. Sorry, my lord, the page 19, annexure C, the order in an execution, my lord, that again at that RS.
Yes,
Your lordship, I got it.
we got it.
Yes, my lord, the RSA number 206.
Right.
Then my lord, after hearing it, then my lord, page, this court do hereby the pending admission of the above RSA, both parties be and hereby directed to maintain a status quo for a period of 2 months from today. Thereafter, my lord, the RSA was admitted. Then your lordship will see the order, my lord, at page, the annexure E. The relevant page is, my lord, at para 6.
Yes.
The record reveals, and so the parties are to, the para 6, my lord, the record reveals that on 4/4 this court directed the party to maintain status quo. On 26th, the matter was admitted, parties were directed to maintain status quo. Then the para 8, if it is legally permissible for the decree holder to take action against the obstructor applicant in OA number, the decree holder is free to proceed against the applicant number IA number 2 of 2018. If somebody filed it, third party, who has nothing to do. Then, but nothing shall be done would affect the appellant herein until the final disposal of this affair. Then your lordship may kindly see the order, next order of the trial court, the execution matter.
Yes.
Next area. Then whereas, well, it is not my application of the one Kudupi Ramanan sent an application. I was directed to be evicted by the who had the status quo order in that execution. Whereas the under mentioned property and occupation of Prabhakar Naik has been decreed to the Vijay Kumar Talpadi, the plaintiff in this, you are hereby directed to put Vijay Kumar Talpadi in possession of the same. You are hereby authorized to remove any person bound by the decree who refused to vacate the same.
Yes.
Well, the decree, the execution petition, Prabhakar Naik, Vijay Kumar Talpadi, Hemalata Sene were parties in RSA number 206. Status quo has been ordered. Then, my lord, now in that, after status quo, the trial court has directed thrown out Vijay Kumar Talpadi and Prabhakar, put the Vijay Kumar Talpadi into position. That is contrary to the order in this, now I have relied upon. Then your lordship may vacate, this is the land property has been mentioned. My lord, in fact, my lord, the judgment and decree was kindly, my lord, in the additional document I have produced. What was the decree and judgment? Page 9, my lord, of the annexure H in the additional document.
Yes.
I will not take much. I will only, this is the partition suit filed by the Hemalata, in 339 of 2005. And Vijay Kumar Talpadi was the respondent number 4. Prabhakar Naik is respondent 2. Then, my lord, in this, the partition has been ordered. When the partition was pending, we get them, he filed a collusive suit by the Vijay Kumar Talpadi and the Prabhakar Naik without making us a party. But there is a collusive suit. That is the Supreme Court said when there was a direct parties are made, the division bench of this said subsequent suit between some other party obtaining is not maintainable. I can place it in Supreme Court also. It is a collusive decree, cannot be enforced against us. I have judgment. Then, my lord, your lordship may kindly see at the page 13, this Vijay Kumar Talpadi filed a suit
mentioned in the suit. This is the order. Then your lordship may kindly see the manner in which they have filed it, page 27. That is an order sheet. That had a relevance, my lord, because I can directly, Supreme Court said already, if it is a fraud played by them, I think, my lord, I think. Huh? ಅಲ್ಲ ಅದಕ್ಕೆ ಯಾವ್ದು ನಾನು ಅದಕ್ಕೆ ಬರ್ತೇನೆ ಏನಂತ ಹೇಳಿ ಹೇಳ್ತಾರೆ
Prayer note.
Huh?
First word.
ಯಾವ್ದು
Page 28, para 8.
ಯಾವ್ದ್ರಲ್ಲಿ
RFA 206 of 80.
page 28.
Yeah, you are complaining that this order is being violated.
ಯಾವ
Page 28 ಅಲ್ಲಿ ತಗೊಳ್ಳಿ RSA 206 of 80.
ಎಡಿಷನಲ್ ಇದ್ರಲ್ಲ ಅಥವಾ ಒರಿಜಿನಲ್ ಅಲ್ಲ
Main papers.
ಮೇನ್ ಪೇಪರ್ನಲ್ಲಿ ಹೌದು ಆದ್ರೆ ನಾನು ಯಾಕೆ ಹೇಳ್ತಾ ಇದ್ದೇನೆ ಅಂತ ಹೇಳಿ 28 ಆಟ್ ಅಲ್ಲಿ ದಿ ಇಂಜೆಕ್ಷನ್ ಆಟ್ ಇಲ್ಲ ಥ್ರೂ ಔಟ್ ಮಾಡ್ಬೇಕಂತೇಳಿ ಹೇಳಿ ಅದನ್ನೇ ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡ್ತಾ ಇದ್ದೇನೆ ನಾನು ನಿಮಗೆ.
Injunction our college suit ಎಲ್ಲ ಬೇಡ sir. You please come to the page number 28 para 8 order in the RSA. What this stay order is granted by the learned single judge.
Yes.
And what you are complaining of this.
Yes.
So that's what we are ನಿಮಗೆ ಏನ್ ಆರ್ಡರ್ ಕೊಡ್ಬೇಕಾದ ಕೊಟ್ಟಾಗಿದೆ.
ಅಲ್ಲಲ್ಲ ಅದರಲ್ಲಿ ಅದು ಕರೆಕ್ಟ್. ನಾನು ಐ ಹ್ಯಾವ್ ಟು ಮೇಕ್ ಎ ಕ್ಲಿಯರ್ ಪೊಸಿಷನ್ ಆಫ್ ಅಲ್ಲಲ್ಲ ಯಾಕಂತ ಹೇಳಿ ಹೇಳಿದ್ರೆ ಐ ವಿಲ್ ಮೇಕ್
No,
I'll read it, my lord. If the legally permissible for the decree holder to take a position of the obstruction or a application in IA number 2 of 2018, decree holder is free to proceed against the applicant in IA number 2 of 2018. My lord, if the legally permissible, they said, if legally permissible, that has not been done at all.
Work it out before the.
Allala, it is not my application. I think, my lord, you are no, my lord, no. Decree against it, they kindly see it, in the execution petition, I think, my lord, it not been a proper on your lordship, last day of sitting it, doing it. My lord, with great respect, my lord, your lordship may kindly see it. My lord, I think the judgment and decree is only against Prabhakar Nayak. What was sought and doing it in the execution petition, my lord, I have produced it, your lordship may kindly, my lord, ultimately, otherwise order of this.
ಶೆಟ್ರೆ ಹೋದ್ ಸತಿ 1.5 ಗಂಟೆ ಮಾಡಿದಿರಾ, ಇವತ್ತು 1 ಗಂಟೆ ಮಾಡ್ತಾ ಇದೀರಾ, ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದೀರಾ.
ನಾನು ಅದನ್ನೇ ಹೇಳ್ತಾ ಇಲ್ಲ ನಾನು. My lord, I think with otherwise, my lord, your lordship hear it or some other, because the record.
We have heard it for 3.5 hours.
ಇಲ್ಲ
having
ಅಲ್ಲ ತಾವು ಆದ್ರೂ ಸಮ್ ಮ್ಯಾಟರ್ ನಲ್ಲಿ ಇದ್ ಮಾಡೋದಂದ್ರೆ ತಾವು ಕೇಳ್ಕೊಂಡು ಮತ್ತೆ ಇಲ್ದಿರೋ ಅನ್ಯಾಯ ಆಗ್ತದೆ. ಅಲ್ಲ ಐದಾರು ಮೈ ಲಾರ್ಡ್, ಐ ಮೇ ಮೇಕ್ ರಿಕ್ವೆಸ್ಟ್ ಬಿಟ್ ಅದು ಬೇರೆ ಬೆಂಚಿಗೆ ಹಾಕಿ ಬಿಡಿ ತಾವು ಹೇಳ್ಲಿಕ್ಕೆ, ಅಲ್ದಿದ್ರೆ ತಾವು ಹೇರ್ ಮಾಡಿ
ಆಯ್ತಲ್ಲ.
ಅಲ್ಲ ಹೇರ್ ಮಾಡ್ಲಿಲ್ಲ, ನಂದು ಎಲ್ಲ ಮೆಟೀರಿಯಲ್ ಇದೆ, ನೀವು ಕೇಳ್ಬೇಕು.
ನಾನು ನಿಮ್ಗೆ 3 ಸತಿ ಹೇಳಿದ್ವಿ, ಫಾರ್ಮುಲೇಟ್ ಮಾಡಿ
ಫಾರ್ಮುಲೇಟ್ ಹೇಳ್ತಾ ಇದ್ದೇನೆ ನಾನು.
ಯಾವ್ದಾವ್ದೋ ಓದ್ತಾ ಇದ್ದೀನಿ
ನಾನು ಯಾವ್ದಾವ್ದೋ ಓದ್ತಾ ಇಲ್ಲ, ಸಂಬಂಧ ಇರುತ್ತೆ ನಾನು ಹೇಳ್ತಾ. ನಾನು ಬ್ರೀಫ್ ಆಗಿ
ಒಂದು ಆಪರ್ಚುನಿಟಿ ಕೊಡ್ತೀವಿ. ದಿಸ್ ಇಸ್ ಪಾಯಿಂಟ್ 1, ದಿಸ್ ಇಸ್ ಪಾಯಿಂಟ್ 2, ದಿಸ್ ಇಸ್ ಪಾಯಿಂಟ್ 3 ಅಂತ ನೀವು ಹೇಳೋ ಆಗಿದ್ರೆ ಇವಾಗ್ಲೂ 5-10 ನಿಮಿಷ ಕೇಳ್ತೀವಿ ನಿಮ್ಗೆ. ಅದನ್ನ ಹಂಗೆ ಹೇಳ್ಬೇಕು ನೀವು.
ನಾನು ಅಲ್ಲ, ನೀವು ಪಾಯಿಂಟ್ ನಂಬರ್ ಬರ್ಕೊಡ್ಬೇಕಲ್ಲ ನಿಮ್ಗೆ.
ಇಲ್ಲ, ನಾವ್ ಇಲ್ಲಿ ಬರ್ಕೋತೀವಿ, ಪೆನ್ ಇದೆ, ಪೆನ್ಸಿಲ್ ಇದೆ, ಎಲ್ಲ ಇದೆ.
ನಾನು ಪಾಯಿಂಟ್ ನಂಬರ್ 1 ಹೇಳ್ತೇನೆ. ಪಾಯಿಂಟ್ ನಂಬರ್ 1ರಲ್ಲಿ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂಡ್ ಡಿಗ್ರಿ ಇರೋದು, ದರ್ ಇಸ್ ನೋ ಇದರಲ್ಲಿ ತಾವು ಒಂದ್ ಸ್ವಲ್ಪ ನೋಡ್ಕೊಂಡ್ ಬಿಡಿ. ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದ್ ನಿಮ್ಗೆ ಆವಾಗ ಓದಿದ್ನಲ್ಲ, ಅದರಲ್ಲಿ ಪರ್ಮನೆಂಟ್ ಇಂಜೆಕ್ಷನ್ that has not been granted by the court.
ಪಾಯಿಂಟ್ ನಂಬರ್
ಅದು ಇದನ್ನೇ 1 is the OS number 330 of 2007 is not binding on us.
330 of 2007 is not binding.
Not binding us. It is a collusive decree obtained by it. My lord, that in your lordship, the collusive decree was obtained by them, 330. That is not binding on us. And that is not maintainable also.
1 ನಿಮಿಷ. It's a collusive decree. Next.
Yes. My lord, then the decree was against Prabhakar Naik, was remove the material from it.
Decree was against Prabhakar
Naik to remove his articles. But the executive court passed an order displacing all of us from the position. The executive court passed an order.
were you displaced or were you?
My lord, they came to me, then
No,
the
executing court
Il-
passed
they-
order.
Past
Inact-
order, they came to position, they tried to throw out with the several
So what is
people.
the result?
The result, my lord, with great difficulty, I was escaped on that day.
So you are
My lord, if your lordship expect me, I should be thrown out, that in the next time they will do it. If the.
They are asking what happened, Anta.
Yes, that is what the.
Executing court passed order against you also, correct?
Yes.
Then what is the next point?
Against me and Prabhakar Naik in spite of the order, in
Amen.
spite of the status quo order. That is my grievance.
Second point, third point.
Third point, your lordship may kindly see the execution nalli ಏನ್ ಕೇಳಿದಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ page 67 ನಲ್ಲಿ page 67 ನಲ್ಲಿ 68 ನಲ್ಲಿ 1 minute ತಾವು ನೋಡಿದ್ರೆ annexure
ನೀವು ಪಾಯಿಂಟ್ ಹೇಳಿ ಆಮೇಲೆ page number.
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪಿಟಿಷನ್ ಅವ್ರು ಏನ್ ಕೇಳಿದಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ ಈವನ್ ದೋ ದಿ ಪ್ರಭಾಕರ್ ನಾಯ್ಕ್ ಆರ್ಟಿಕಲ್ ಅಂತ 7 ದಿವಸದೊಳಗೆ ಹೊರಗೆ ಹಾಕ್ಬೇಕಂತ ಮಾಡಿದ್ದಾರೆ. ಇವ್ರು ಏನ್ ಕೇಳ್ತಾರೆ ಅಂದ್ರೆ ಡೆಲಿವರಿ ಅಪೋಸಿಷನ್. Page 68 and 69 may be kindly been seen.
Page 68 and 69 ಇಲ್ಲೇ ಇಲ್ಲ ಅದರಲ್ಲಿ.
ಅಲ್ಲ ಅದು ಎಡಿಷನಲ್ ಇದ್ರಲ್ಲಿ ಇದೆ ಡಾಕ್ಯುಮೆಂಟ್.
ಏನ್ 68 ಅಲ್ಲಿ ಏನಿದೆ?
ಅಲ್ಲ ಎಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್.
ಏನ್ 68 ಅಲ್ಲಿ?
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪಿಟಿಷನ್ ನಲ್ಲಿ ಡಿಕ್ರಿ ಇರೋದು ಒಂದು, ಅವ್ರು ಕೇಳೋದು ಮತ್ತೊಂದು, ಕಾಂಟ್ರರಿ ಟು ದಟ್.
ಮುಂದೆ ಹೇಳಿ. ಆಯ್ತು, ಅದ್ ನೋಡಿ ಆಯ್ತು.
ತಾವು ಇದರಲ್ಲಿ ಜಿ ನಲ್ಲಿ ಇದೆ page 68 ಲಾಸ್ಟ್ ನಲ್ಲಿ ಅವರೇ ಹೇಳ್ತಾರೆ, ಡಿಕ್ರಿ ಡೈರೆಕ್ಟ್ ಬೈ ವೇ ಆಫ್ ದಿ ಮ್ಯಾಂಡೇಟರಿ ಇಂಜೆಕ್ಷನ್ ಡಿಫೆಂಡೆಂಟ್ ಟು ರಿಮೂವ್ ದಿ ಬಿಲಾಂಗಿಂಗ್ಸ್ ಆಫ್ ದಿ ಪ್ಲೇಂಟಿಫ್ ಎಸ್ಟೇಟೆಡ್ ಪ್ರಾಪರ್ಟಿ within 8 days from the date of the order, or the plaintiff is liberty to get the same executed through the process of this order. ಅವ್ರು ಕೇಳೋದನ್ನ ಇಲ್ಲಿ ಕೇಳಿದ್ದಾರೆ. ಮೂಡ್ ಆಫ್ ಯಾವ್ದು under order 21 by directing the plaintiff.
What is the point, Mr.
In spite of that, they are the acting against the judgment and decree. That is what I am placing it.
ಕೊಡಿ, ಅದು ಕೊಟ್ಬಿಡಿ.
Yes. But whether the court can pass an order contrary to the judgment and decree.
Which court?
The executive court. But I don't take much. That's only.
You have taken 45 minutes now. What I don't take?
ಇಲ್ಲ ಅದರಲ್ಲಿ ಅದು
You must now come to the point. Otherwise, simply we are closing your case.
Relevant ನಾನು ಓದ್ತೇನೆ ಅಂತ ಹೇಳಿ ಕೇಳಿದ್ದು. The one first judgment you last may kindly see.
No, the most relevant among this. We will not keep on opening.
The executive court not to go beyond the decree and really
settled position, Mr.
Israel. ಇದೆ ಇದ್ರು ಪ್ರೊಸೀಡ್ ಆಗ್ತಾರಲ್ಲ ಅಂತ ಹೇಳಿ
ಸಪರೇಟ್ ಕಂಟೆಂಪ್ಟ್ ಹಾಕೊಳ್ಳಿ ಸರ್, ಯಾರು ಬೇಡ ಅಂತಾರೆ. ಯು ಪ್ಲೇಸ್ ಸಪರೇಟ್ ಕಂಟೆಂಪ್ಟ್ ಟುಡೇ ಇಟ್ ಸೆಲ್ಫ್.
ಯಾವ್ದಕ್ಕೆ
ಹಾಕಿ ಈ ರೀತಿ ಮಾಡ್ತಾ ಇದ್ದಾರೆ, ವೈಲೇಷನ್ ಆಫ್ 206.
ಹಾಗಾದ್ರೆ ಲಿಬರ್ಟಿ ಕೊಟ್ಟು ಹೇಳ್ಬೇಡಿ, ಫ್ರೆಶ್ ಕಂಟೆಂಪ್ಟ್ ಹಾಕ್ಬೋದು ಅಂತ ಹೇಳಿ. ಅಲ್ಲ, ನೀವು ಲಿಬರ್ಟಿ ಕೊಡಿದ್ರೆ ನಾವು ಹಾಕ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ. ಇಲ್ಲ, ನೀವು ತಾವು ಬಾಯ್ನಲ್ಲಿ ಹೇಳಿದ್ರಿ, ಬಾಯ್ನಲ್ಲಿ.
ಆಯ್ತು, ಆ ಲಿಬರ್ಟಿ ಕೊಡೋಣ, ಬರ್ಕೊಳ್ಳಿ. We will give you that liberty. Listen.
Yes, then ಅಲ್ಲ 1 minute ತಾವು ಹೆಚ್ಚು ನಾನು ಒಂದೊಂದು ಎರಡೇ ಸೆಂಟೆನ್ಸ್ ಹೇಳ್ತೇನೆ.
Sorry.
ಅಲ್ಲ ಫ್ರೆಶ್ ಲಿಬರ್ಟಿ.
We will grant you liberty. That's the learned advocate at length, Mr. Shetty at length. We find no error in this order, full stop. Next, however, he prayed that some third parties are filing. Parties are filing applications in the executing court, in execution case number
132 of 132 of 2016.
132 of 2016, and making attempts to dispossess the complainant. He seeks leave to seek appropriate action, initiate appropriate action against such persons, full stop. Such attempt, full stop. It is needless to mention that if any application is filed seeking any direction against the complainant in the execution proceedings, he is always entitled to defend that case, full stop, and take such appropriate action in accordance with law open to him, and if so advised. With these
Well,
observations.
may make one submission. But there is, I don't find the error of the order. But all contention of mine left open for filing the separate contempt petition. Only my endeavor is, your lordship, all.
ಅದಕ್ಕೆ ನಾವು separate action ನೀವೇನ್ ಬೇಕಾದ್ರೂ ಮಾಡ್ಕೋಬಹುದು ಅಂತ ಹೇಳಿದ್ವಿ.
ನಾನು ಮಾಡೋ ತಾವು ಹೇಳಿದ್ದನ್ನ ನಾವು ಬರೆದ್ರೆ ಆಗ್ತದೆ. ಇಲ್ದಿದ್ರೆ ನಿಮ್ಮ ಆರ್ಡರ್ ಎಗೇನೆಸ್ಟ್ ಆಗಿ ಯಾರು ಏನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. ನೀವು ಲಿಬರ್ಟಿ ಕೊಡದಿದ್ರು ಏನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ.
ಕೊಟ್ಟಿದ್ದೀವಿ ನಾವು.
ಅಲ್ಲ, ನೀವು ಹೇಳಿದ್ರಿ ಏನು ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರಿ. ಆಲ್ ಕಂಟೆನ್ಷನ್ ಆಫ್ ದಿ ಫ್ರೆಶ್ ಹಾಕ್ಲಿಕ್ಕೆ ಅಂತ ಹೇಳಿ ಬರ್ದ್ರೆ ಅದು ತಾವು ಆರ್ಡರ್ ಬರೆದ್ರೆ ಮಾತ್ರ ನಾವು ಮಾಡ್ಬೋದು. ಬಾಯಿನಲ್ಲಿ ಹೇಳಿ ಬರೀದಿದ್ರೆ ಅದಾಗಲ್ಲ.
And making it clear, we, as prayed for, we make it clear that this order, the observations made in this order shall not come in the way of complainant filing any, initiating any proceeding against any third party.
ಅಲ್ಲ, ಥರ್ಡ್ ಪಾರ್ಟಿ ಅಲ್ಲ, ಇವ್ ಥರ್ಡ್ ಎಲ್ಲ ಇಲ್ಲಿದ್ದವ್ರ ಹತ್ರ ನಾವು ಥರ್ಡ್ ಪಾರ್ಟಿ ಇಲ್ಲೇ ಇರುವುದು, ಎಲ್ಲರೂ ಇಲ್ಲೇ ಇದ್ದಾರೆ.
ಮತ್ತೇನ್ ಮಾಡುದು?
ಅಲ್ಲಿ ಥರ್ಡ್ ಪಾರ್ಟಿ ಅಲ್ಲ. ಈ ನಾನು ಯಾರು ಡಿಸೋಬೆ ಆಲ್ ಕಂಟೆನ್ಷನ್ ಲೆಫ್ಟ್ ಓಪನ್ ಟು ಬಿ ಫೈಲ್ ಫ್ರೆಶ್ ಪಿಟಿಷನ್ ವಿತ್ ಲಿಬರ್ಟಿ ಅಂತ ಹೇಳಿ.
ವಾಟ್ ಫ್ರೆಶ್ ಪಿಟಿಷನ್?
ಯಾಕಂದ್ರೆ ಇದ್ರಲ್ಲೇ ಈ ಆರ್ಡರ್ ಡಿಸೋಬೆ ಮಾಡಿದ್ರೆ
ಕಂಟೆಂಪ್ಟಿಂಗ್ ನಾವು ಮತ್ತೆ ವಿಲ್ ನಾಟ್ ಪರ್ಮಿಟ್ ಯು ಟು ರೀಓಪನ್. ಅದಕ್ಕೆ ಬೇಕಾದ್ರೆ ನೀವು RSL ಮಾಡ್ಕೊಳ್ಳಿಕ್ ಕೊಡ್ತೀವಿ.
ಅಲ್ಲ, ವಿತ್ ಗ್ರೇಟ್ ರೆಸ್ಪೆಕ್ಟ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಮೈ ಲಾರ್ಡ್, RSA ನಲ್ಲಿ ದಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪಿಟಿಷನ್ ಎಲ್ಲ ಸ್ಟೇ ಆಗಿದೆ. ಅದನ್ನ ಡಿಸೋಬೆ ಮಾಡ್ತಾರೆ ಅಂತ ನಾನು ನಿಮ್ಮ ಹತ್ರ ಬಂದ್ರೆ ಅದ್ರಲ್ಲಿ ಮಾಡಿ ಅಂದ್ರೆ ಅವ್ರಲ್ಲಿ ಯಾಕೆ ಮಾಡ್ಲಿಕ್ಕೆ ಏನಾಗ್ತದೆ? ತಾವು ಅದಕ್ಕೆ ಅಲ್ಲ, ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಆಲ್ ಕಂಡೀಷನ್ ಲೆಫ್ಟ್ ಓಪನ್ ಅಂತ ಹೇಳಿ ವಿತ್ ಲಿಬರ್ಟಿ.
Making it clear that in a fresh, if any fresh proceedings are initiated, the same shall be considered wholly uninfluenced by the observations in this order. The fresh. Yes, next.
ಆರ್ಡರ್ ಮಾಡಿ.
For the appellant in this matter, my lord.
Yes, please.
For the pleading application.
The appeal in RFA 671 of 2005 is hereby allowed. Judgment and decree dated 24/2/2005 in YS 2443 of 1984 is set aside. Suit in YS 2443 of 1984 is dismissed. Appeal in RFA 1508 for 15 is dismissed with cause.
Grateful, my lord.
For the appellant in this matter, my lord.
Appeal is dismissed. Appeal is allowed. Order of the refusing and performance is hereby confirmed. Plaintiff is entitled to recover 93,92,500 with interest at 18%.
For the petition.
Point number 2.
WP 21951 of 22 is partly allowed. Prayer clause 1 and 2 are rejected. Prayer clause 3 is allowed, and bank is directed to refund the amount received from the auction purchaser, respondent number 2, with simple interest at 18% from the date of deposit until the date of refund in an outer limit of 8 weeks from the date of receipt of copy of this order. Liberty is reserved to auction purchaser to claim expenditure, if any, incurred on the land by placing material before the DRT. DRT shall adjudicate such claim, if any, the auction purchaser, and determine the compensation payable. Petitioner shall deposit rupees 3,41,07,747 together with the interest to be computed as per the contractual rate of interest till the date of deposit within 8 weeks from the date of this order. WP 21752 of 2022 dismissed. WP 21725 of 22 is dismissed.
Pay for the appellant.
Appeals allowed order dated September 12, 2023 and WP 9068 and 11875 is set aside. WP 9068 of 23, WP number 11875 are dismissed, no cause.
Much obliged.
Appeal does not merit consideration, dismissed.
Obliged.
Sure. Yeah, the pastor. Which is pastor? Yes, what is it? Please.
Yes.
Yavadaru kodi ma?
The Lordship's kind permission,
Yes,
that's item number 5.
yes.
Because I think the refund is ordered.
I'm okay with this.
Yes, refund is ordered.
But in fact, there was no such prayer in the plaint.
That is our judgment, sir.
No.
So now the
Just 22.
that says unless that prayer is sought.
Anything else?
The order, judgment has been pronounced, sir. Thank
I
you.
understand, Lords, but the law is, Lords, unless it is prayed for, it can't
Sir,
be.
we can't hear argument now. Judgment is
I'm not saying,
pronounced. Thank
Lord,
you.
I'm only clarifying the legal position.
That's all right. Maybe that's your viewpoint. Doesn't matter. We have passed an order. Thank you.
Settled
Yes, thanks.
principle.
What is this?
Yes, my lord, this is correction. my
My
lord.
lord, this correction which was to be done,
Lots, I agree, lots. That is
May I
23 has to be.
Which
has
page?
to be added.
Yes.
Page number 50.
Page 50.
50.
So it must be
So
20
22 has to be done as 22.
in line 3, correct?
Yep.
Right. And line 5, it must be 23-24.
No. It'll be the same thing. Same.
You have done, you have done the correct.
but-
Show it to him.
But the application is there with their consent.
My lord, may kindly have, my lord, may kindly have this with my lords. While
The
I'll also,
application says.
while I'll also show
The
this
application
to,
only says about 22, 23.
my lord, let
Kindly
me,
see the prayer column.
let me point out, my lord. There are 4 petitions there. My lord is saying,
We are concerned with this, Mr. Now.
correct, but that's what I'm pointing out. my lord. There are 4 petitions there. Page 50 is what I've folded
Right.
and given to my lords. The first 3 pertain to academic year 22-23 batch. The next one pertains to 21 and 22 batch.
Right.
My lords have passed a common order. Therefore, all that is required now is, my lord may now come to the order. First para. In the academic year 2021-22, what is required is to add 22-23, not substitute it,
22-23.
and 22-23.
Right, added.
Below that, the future academic year, which is now 23-24, not 22-23.
23-24.
And what was not permitted was 22-23.
Then
So-
in the last line,
That's all, that's all.
no, there is you have written
And I've added the, yes, these 2 years are not permitted.
20. That's all?
That's all the correction
Ah,
in that. way.
added.
And another petition is there, which is independent, standalone, 22-23 batch.
That is
For
also
that,
there.
the correction is,
Number 16, my lord.
that is, there the correction is in this fashion, my lord.
Where is that? Where is that? Kodima? All right, they ordered, correction ordered, they liddang madbidi. Correction ordered. Yes.
My lord,
Which
may
is the
I-
other one?
Yes, 16.
For that also, I'm just passing on so that there
Please
may
give.
not be any confusion.
That is item number
16.
16. This is 15, is it? The one which you have passed now?
Yes, yes.
Right. 16, what is the order?
There, it pertains to 22-23. Therefore,
then-
21-22 scores off and 22-23 is substituted in the second line of page 5. Below that, future years.
23-24. That's all.
That's all.
Correct? Yes, ordered.
My lord, there is one more writ petition also which is not put up. My lords, I'm, because.
Then you get it corrected later. Thank you. You can't do it. Yes, next. Which is the end of list? Who has come? Yes, what is this?
Yes.
Your government?
Yes, my lord.
What is the matter about? Why, what is the urgency for government?
My lord, in this case, my lord, the Learned Single Judge is directed to the Chief Secretary to take actions against the Deputy Commissioner. So
So
that
what?
was not taken, therefore the contempt is issuing on this, the
So
writ
what may
petition.
have asked to take action?
My lord, in this, that the petition order itself is not correct. Why it is not correct? So there is a land acquisitions situated in the
So
Bidadi.
for years and years, you don't take action. Whenever writ petitions orders are passed, you don't take action. When such an order comes, you come at the last
My
minute.
lord, on merit of the case we are submitting, on merit of the case we are
I mean, it's routine course. No? What is such an urgency that before 12 o'clock, the order must be passed? What is the date of the order?
date of order, my lord, this, the Single Judge order.
What is the urgency?
31.
Unless the notice is issued to the other side, how can any order can be passed?
There is a,
Either he's Advocate General, no? Then please sit down.
my lord, there is a Supreme Court judgment saying that once a land acquisitions is notice issued, subsequently that landowner cannot be sell the property. So that was the suppressed the fact before the Learned Single Judge and subsequently obtained.
Why did you not mention to the Honorable Single Judge?
My lord, this.
You are the custodian of records.
Please, my lord, but
Then-
in this case, my lord, that is suppressing the fact of the case by the petitioner before the Learned Single Judge and subsequently obtained the order quashing of the notification. And there is form number 3, para number 3 of the Learned Single Judge order, page number 5, para number 3, my lord.
Para number 3.
Please, my lord.
Para 3 and para 4 is perfectly all right.
Correct, my lord. So as per the Supreme Court judgment,
2 additional Advocate Generals have appeared in that matter.
myself and Hamad, my lord.
So,
Yeah, in this case, my lord,
no, you must tell us on merits.
merit,
The fact of the matter remains that you have made only one plea before the Honorable Single Judge saying that the land was purchased by one Lakshmama. The finding of fact is that in the considered opinion of this court, para 4, it is irrelevant for consideration of an application for filed in the hands of such and such under section 95 of the Land Revenue Act seeking conversion of the land. What is wrong with this?
wrong is here, my lord, the moment once owner of the property and issued the acquisition land, during the acquisition proceedings of the notice, they can't subsequently sell the property. There
That's a
is a
different
Supreme,
matter.
that is, there is the
That
Supreme Court
whoever
judgment.
whoever is aggrieved by such things, he will go. Why is Deputy Commissioner concerned about?
Not, why, Deputy Commissioner concerned, my lord, the subsequent purchaser made an application.
You
to
are
the-
not a party, Deputy Commissioner is not a party to private litigation.
My lordship is a direct issue, so why the Deputy Commissioner is involved in this case? That's what I'm answering.
Exactly. That's the reason
Yes.
that the Honorable Single Judge has directed action against it.
What is the contribution in the Deputy Commissioner I'm submitting, my lord? So that the Lakshmama, after purchasing the property, made an application to the Deputy Commissioner. Deputy Commissioner rejected their conversion applications and thereafter they come to the High Court. So thereafter come to the High Court is quashing the notification. Based on that, so they filed the writ petition saying that the
But sir, now the writ petitioner has.
para number
purchased the
8 has to be seen, Mandal. Para number 8.
Government's case itself is the writ petitioner has purchased the property from Lakshmama.
Correct.
He is the title holder.
Correct.
He is entitled to make an application. Title holder is entitled to make an application.
That
for
is wrong, my
conversion.
lad. That is how it is wrong by the ratio of the Supreme Court.
No. Those are all on facts. Supreme Court will come only where is a statement of law. If you want, file a review before the honorable single judge.
The moment once is acquisition notice is given, the Supreme Court says that you cannot sell the property. There is a directly judgment of Supreme Court, my lad.
Notification has been.
Mama execute sale deed on 23/3/2019, your lord, in favor of the respondent hearing, who is the petitioner, which order we are assailing here. On 23/3/2019, she sells the land, she executes the sale deed. Thereafter, suppressing that, she comes before the High Court and makes a writ petition and obtains a order on 20/10/2020. The settled position is that, your lordship, if your lordship permit me, I'll.
No, please tell us.
Yes.
So
The issue is that, the legal issue is that, once the landowner has executed the sale deed and received the consideration, she does not have the locus standi to assail the notification. She suppresses that, she has executed the sale deed, she files a writ petition and obtains the order of the quashing of the notification. Thereafter, the subsequent purchaser comes before the court. Because if he first comes before the court, Shivarna's case and Prem Kala's case, it is a hindrance for them, for the subsequent purchaser. He cannot assail the notification. So he keeps quiet, and the original landlord after executing the sale deed.
So what you should have done? You should have got that order set aside.
Now it came to our notice, your lordship. We have.
See, if the
Yes.
if this court has quashed the acquisition proceeding, you should have gone before that in that proceeding and got that order set aside or reviewed.
Yes, your lordship. Now we made a communication to get the GO, and it is also prepared.
That's precisely the point.
Yes.
You don't do. You see, these are all vertical remedies.
Yes.
You should. The right royal way is to get that order set aside
Now,
by filing a review petition or whatever.
technically, we are supposed to obtain the order in regard to WP 8070 of 2020, where the landowner got that we are.
That's a different matter.
Yes, sir.
What we are also concerned and what we are also why we are in agreement with the honorable single judge is.
Yes.
You do not follow that right procedure.
Yes.
You come in on a lateral entry and then say that the honorable single judge is not wrong at all.
Yes, sir.
He is perfectly all right. This some action has to be taken against the deputy commissioner because you read beyond what is written in the file. That's the whole difficulty about it.
Yes.
In the previous case also which you are there, always the government lawyers and the central government, state government lawyers, you are all only amicus curiae.
Yes, your lordship.
You are not adversarial litigants.
Yes, that we will do, your lordship. In
Then we will
meantime,
do it.
your lordship, our humble.
This is the whole
submission that
difficulty, sir.
Apart from this, your lordship, we should not lead to precedents because these people are executing the sale deeds.
No. It will not lead to precedent. If you are so advised, get that order set aside.
Yeah, we will. Meantime, your lordship, a direction.
Action has to happen.
Because
How a government officer is above law, sir?
No, it is not as so, your lordship. It was not properly brought before the honorable single judge.
So two advocate generals could not bring this.
No,
this is what the honorable single judge has recorded here.
Only when it came before the court.
Please read para 3.
Yes, your lordship.
Two learned additional advocate generals have appeared in this matter.
Yes, sir.
Then
yes, your lord. What happened?
ಹೋಗಲ್ಲ ಓದಲ್ಲ ಬರೆಯಲ್ಲ ಜಡ್ಜ್ ಹೇಳಲ್ಲ ಇಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು
ಇಲ್ಲ ಅದೇನಾಯ್ತು.
This order is not wrong.
It is right.
Yes.
ನಾನು ಅಲ್ಲಿ ಅವತ್ತೇನಾಗಿದೆ ನಮಗೆ ಫೈಲ್ ಬಂದಾದ್ಮೇಲೆ ಗೊತ್ತಾಗಿತ್ತು. Then we got into this and we obtained all the 8070 ಎಲ್ಲ 2020 ನಲ್ಲಿ dispose ಆಗಿದೆ.
So you look into the papers at leisure and you see you suffer the order.
ಅಲ್ಲ ಅವತ್ತೇ ನಮ್ ಫಸ್ಟ್ ನಮ್ಗೆ ಬಂದಾದ ತಕ್ಷಣ ಅದನ್ನ we brought to the notice of the because a 1991 Act, Section 3 comes into it is very clearly.
No, sir, you have no case on merits. In our view,
Yes,
if
sir.
at all, if you had, and if you are so advised,
6070.
you should have got the other.
Consult.
If you agree, then why you have moved?
Para number 8 consult. Para number 8 ಬಂದ chief secretary para number 8 is concerned.
ಅಲ್ಲ RTC ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟು ಮಾರಾಟ ಮಾಡೋದು ಇನ್ಫ್ಲೆಕ್ಚುಯಸ್ ಆಗುತ್ತೆ ಅಷ್ಟೇ. ಟು ದಟ್ ಎಕ್ಸ್ಟೆಂಟ್ ಮಂಡೇ ವಿ ಆರ್ ಮೂವಿಂಗ್ ಇಟ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್. ಮಂಡೇ ಅದು ಸೇಲ್ ಡೀಡ್ ಎಲ್ಲ ಕಲೆಕ್ಟ್ ಮಾಡೋದಿತ್ತು.
Delay ಇದೆಯಾ? Notice.
ಅಲ್ಲ ಇದು ಒಂದು ನಾಟ್.
Sir, how can you
Yes,
give 145 days delay is there? Notice. Yes, next. What is this CSTA?
Was moved. Not in para 6 of the first appeal.
Para 6?
Para 6 of the order, it is stated that I have no objection. In fact, we have a strong objection. That's a mistake. It is not.
Whatever is written, whatever you have said, you have said.
And even in the operative portion, it is shown as.
Operative portion,
You correct.
lordships for an early hearing, my lord, to restrain your lordships from retiring today. My lord, I want to express a very deep gratitude to your lordships, my lord, for all that you've done. And I think, as they say, some good things sometimes have to come to an end. But I think in your case, it's a little early, my lord, for all of us.
But we do hope that in some form or shape, the innings does continue a lot. We have the privilege of interacting with the lordships on a routine basis.
And of course, some unpleasantness notwithstanding on the last day. I think your lordships must have much better memories, my lord, to take back.
No.
For me, this is a wonderful occasion. Last day I appeared as additional speaker for your lordship. After last time struggling, I was able to appear before you.
On behalf of, I think I speak on behalf of the entire bar, Malas, we place on record our sincere gratitude for all the service, Malas, to the institution, to the state. Malas, we will all, I'm sure unanimously, the bar will support me in submitting that we will sorely miss your lordships.
We wish you.
Same here.
In terms of, even in a lawyer's mind, how to simplify a matter, we've learned a lot from your lordship. Just to keep it simple, just a great lesson and an indicator to so many of us, and I'm sure more junior members of the bar.
Very great, very great.
We are now getting the list at 7:30.
I have tried to implement as much.
That has come.
We wish you all the
All
best
the very
for
best,
your
Malas.
future endeavors.
Thank you so much. Thank you.